Their seats, please. Thank you. We have a quorum of 6 members, of whom at least one is from each of the House of Shannon Éireann and Oireachtas Éireann. Beginning in public session, is that agreed? Agreed, we're now in public session. May I remind members of the committee, members in the public gallery, witnesses and members of the media, and that mobile phones must be in the off position for the duration of the meeting, as they do interfere with the broadcasting equipment even when on a silent mode. Before we commence with our main business of this morning's meeting, as chairperson of this committee, may I, at the beginning, wish everybody here a very happy and prosperous new year, and also may I ask that we would record our deep-felt sympathy on the death of our colleague and good friend, the late Minister Shane McEntee, who died tragically before Christmas. Our sympathies in particular go to his wife Kathleen and children, and may I ask you at the beginning of the meeting to stand for a minute's silence, please. Members of the committee, you're all very welcome to our meeting this morning here in the Shannon Chamber. May I, at the beginning of our meeting, thank the Cathaoirleach of Shannon, the Clerk of Shannon and the Shannon CPP for facilitating our request. This is the first session in a series of hearings that the Joint Committee will be conducting over the next 3 days to discuss the implementation of the government decision following the recent publication of the expert group report into matters relating to cases ABC versus Ireland. On Tuesday, December the 18th, the government decided to accept the expert group's suggestion that the European Court of Human Rights judgment in the ABC versus Ireland to be addressed by putting in place legislation and regulation setting out our current constitutional position as stated in Article 43(3) of the Constitution as interpreted by the Supreme Court. I and members of the committee are conscious of the complexity and the sensitivity of this issue, and for these same reasons the government decided that the process of drafting the heads of the bill and draft regulations in line with its decision will not occur until this committee, the Oireachtas Committee on Health and Children, has conducted hearings over 3 days this week. The government has stated that the aim of its action in this matter is to ensure clarity and legal certainty in relation to the process for the determination of whether a pregnancy is permissible in cases where there is a real and substantial risk to life as opposed to the health of a woman as well as that pregnancy. In doing so, we must ensure that we must take full account of Article 43(3) of the Constitution. The government's decision is confined to the option to be pursued in order to bring regulation and rules to an area which is currently unregulated. It is my intention, with your cooperation as chairman of the committee, to facilitate a discussion on current medical guidelines and legal practices with regard to legal and medical expertise, to ascertain the difficulties, if any, legal and medical encountered by medical experts when they're making decisions, and to provide a forum for the expression of views recognising the broad range of views in this particular matter that exists. When these meetings have concluded, this committee should furnish a report to government summarising the contributions it has heard and received from various stakeholders, both orally and verbally and written. Over the course of the next 3 days, the committee will hear a wide range of views from legal and medical experts, as well as from churches and advocacy groups, on what issues need to be considered when implementing the government decision to accept the expert group's suggestion. I hope that this will be a positive and constructive discussion, giving each witness and committee member the opportunity to express their views, and that we will respect and listen to each other. I intend that our hearings will be conducted in a balanced, fair and calm manner, focusing on the issues which need to be considered in drafting of the heads of the bill. While we all recognise that many people have divergent and deeply held views on the issues involved, it is vital that these meetings are held in a manner that is respectful and tolerant. In drawing up the panel of witnesses and speakers to these hearings, members of this committee and indeed members of the Oireachtas who are not members of this committee have suggested names, relevant panellists who might be invited to attend. These suggestions were considered and invitations were subsequently issued. In selecting panellists and witnesses to appear before the committee, we as a committee have done our best to ensure a fair and balanced expression of views as well as guaranteeing that we hear from experts, both academic and practising from the legal and medical field. It is of the utmost importance that the Government and the Oireachtas are fully aware of the current medical guidelines and practice, aware of how these guidelines have been implemented and operated over recent years. In order to ensure that all attending and participating in these hearings have a full understanding of the matter at hand, my committee colleagues and I strongly are of the view that it is important that we provide a background and context to the Government decision. For this reason, the hearings this morning will commence with a statement from the Department of Health, which will provide the background to the Government decision, including the European Court judgment in December 2010, which led to the establishment of the expert review group by Minister Riley in January and subsequent publication. I want to state from the outset that the committee is understanding of the fact that the Department of Health has not yet developed policy decision detail on this particular matter, and our hearings this week will no doubt feed into that development in the heads of the drafting of the heads of the bill and draft regulation. I do look forward to Ms Geraldine Luddy from the Department outlining us with a background and an outlining report. I also want to welcome this morning Mr Kerry Murphy from the Medical Council, who will be with us as well. And later on this afternoon we will hear from the masters of maternity hospitals as well as our country's top practising academic psychiatrists. The insights that will be provided by today's witnesses will frame the basis on which we will, first of all, proceed as a committee, and secondly, assist Government in the need to understand, acknowledge and assess the views and experiences of small witnesses before this committee in the coming days. Tomorrow we will hear from legal experts who will outline existing constitutional and legal provisions, and there will be discussion on how to frame legislation as per the Government's decision. And on Thursday our committee will receive the views of the churches as well as some advocacy groups and the decisions being implemented by Government. So I would ask that my colleagues in this committee and members of the Oireachtas who have joined us to ensure that we elicit as much information as possible from our witnesses. I am conscious that we are meeting in the eye of the nation, and I would hope that, again, that given that this is a very complex issue, that many people hold divergent and strong viewpoints, that we will have a constructive, positive and comprehensive debate over the coming days, which we can report back to Government. Thank you very much. As per our meeting last night, where we agreed in terms of the rubrics of the meeting, there will be opening presentation by the Department of Health, there will be a statement by the Medical Council, there will be questions by members of the committee of 80 minutes, 60 minutes for members and 20 minutes for non-members, and then 10 minutes at the end for summation. And I would like to remind members that it should be questions rather than second stage speeches, and that the 60 minutes and the 20 minutes allows for time for responses from the witnesses as well. Okay? So,
just in relation to, Chairman, just in relation to the submissions and that, there's a lot of submissions that are being made. Not everyone has been selected orally to come before the committee to make that presentations. Will they be all put up on the website?
They will be put on the website.
Made available.
Yes, they will. Yes,
for members of the public.
And there are submissions available on the door, at the table on the way in.
That's grand. And the committee would have signed off on the witnesses that have been selected to come before.
Yes. Yes.
Okay.
And the chairperson was given plenary powers between the last meeting and the meeting of last night as well.
Thanks.
Senator Bradford.
Yes, thanks very much, Chairman. Just a quick question, and thank you for your initial and very inclusive introduction to the meeting. Could you try to give us some little degree of background as to how the various groups were selected to make oral presentations? My understanding is that, you know, all groups now, those groups before us today and groups who are not coming before us have by now made...
Sorry, Senator Bradford. The only purpose of today's meeting, the committee has signed off on the witness list, and we're moving on to hear opening statements.
Could you give us an indication as to...
Not at this particular moment, no. That's been decided and agreed by the committee. Sorry. Okay. Thank you.
Can I ask, Chairman?
Okay, before... Sorry,
Chairman,
very briefly, Senator Watts.
Yeah, just
very briefly.
Is it the submissions for today, for the hearings now? They're available outside,
yes,
are they?
Yes,
okay, thank you.
And the other submissions will be available during the course of the week.
Thank you.
To members and non-members. Okay, may I begin by welcoming again Ms Geraldine Luddy from the Department of Health, and to welcome Ms Caroline Spillane, Chief Executive of Irish Medical Council, Mr Kerry Murphy, the President, to our hearings. Before we commence, can I remind people in the position of privilege, witnesses are protected by absolute privilege in respect of the evidence you're to give to the committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are therefore entitled only to a qualified privilege in respect of your evidence, and you are directed only evidence connected with such a matter of these proceedings to be given, and you are asked to respect the parliamentary practice to the effect that where possible you should not criticise nor make charges against any person or persons or entity by name in such a way as to make him or her identifiable. And members are reminded of the long-standing parliamentary practice or ruling of the Chair to the effect that members should not comment on, criticise or make charges against either a person or persons outside the House or an official, either by name, in such a way as to make him or identifiable. So, Ms. Luddy, you're very welcome, and ask you to go proceedings.
Point of order. For all that Ms. Luddy's submission isn't available yet outside.
We haven't got that yet, that's correct. Yeah. Nobody has a Senator Watch. Could you take a seat, please? Could you resume your seat, please?
As a constructive suggestion, would you start with the IMO then, see that we have their comment?
I'm going to start with Ms. Luddy. Thank you, Ms. Luddy.
Thank you. Good morning, Chairman and members of the committee. Thank you for the invitation to attend these hearings and to set out the context of your deliberations and provide some background to the government's decision last December on the implementation of the judgment of the European Court of Human Rights in the ABC versus Ireland case. I'm very pleased to be here today, and I look forward to the debate that will take place and the input of your many invited guests. We are confident that these hearings will assist us in examining the issues involved in the implementation of the judgment and in formulating a legislative response that will stand up to public and parliamentary scrutiny. As you are aware, last December, prior to the Dáil recess, the government approved the implementation of the judgment of the European Court of Human Rights in the ABC case by way of legislation and regulation within the parameters of the Article 43.3 of the Constitution as interpreted by the Supreme Court in the X case. They also agreed to make appropriate amendments to the criminal law in this area, namely the 1861 Act. This is in line with recommendations that a number of previous consultations on this subject have taken place in the past. As the expert group has pointed out, the issue of how to provide for the X case has been considered by other eminent groups. For example, the Constitutional Review Group in 1996, those who produced the Green Paper in 1999, and your colleagues in the All-Party Oireachtas Committee on the Constitution in 2000. They all concluded that legislation in some form is the most appropriate way in which to regulate access to lawful abortion in Ireland. Now that this decision has been taken, the government will, in the coming months, be examining the procedural options for the operation of a scheme to guide clinical decision-making for doctors who find themselves dealing with pregnant women in very difficult circumstances, whereby there is a real and substantial risk to their lives and where a lawful termination is one of the options to be considered. These hearings are very important in this process. These procedural options are complex given the technical, medical, legal and health service organisational implications. The legislative provisions on termination of pregnancy in Ireland date back to 1961, and for the last 30 years they have been fraught with much controversy. Abortion is currently a felony under the 1861 Offences Against the State, the Persons Act, and a sentence of penal servitude for life can be imposed for the offence. In 1983, the first of Ireland's referendums on the subject was held, and during the 1980s, several landmark court cases were taken. The referendum introduced a new section in Article 43, which was to guarantee the right of life to the unborn. This section became Article 43.3 of the Irish Constitution, or the Eighth Amendment, and provides as follows. The state acknowledges the right to life of the unborn, and with due regard to the equal right to life of the mother, guarantees in its laws to respect and as far as practicable by its laws to defend and vindicate this right. In Attorney General versus X in 1992, the Supreme Court considered the meaning of the Eighth Amendment in the circumstances that arose in this case. X was a 14-year-old girl who became pregnant as the result of an alleged rape. The girl and her parents wished to travel abroad so that she could have an abortion. The issue of having scientific tests carried out on retrieved fetal tissue so as to determine paternity was raised with An Garda Síochána. The Director of Public Prosecutions was consulted and in turn informed the Attorney General. An injunction was obtained to restrain the girl from leaving the jurisdiction or from carrying out or arranging or carrying out a termination of pregnancy. The High Court granted an interim injunction and the case was appealed to the Supreme Court. A majority of the Supreme Court rejected the view of the High Court that the risk that the mother would take her life, if not permitted to have an abortion, was of a lesser and different order of magnitude than the otherwise certain death of the unborn. On the other hand, the majority of members of the Supreme Court held that if it was established as a matter of probability that there is a real and substantial risk to the life, as distinct from the health of the mother, then this real and substantial risk could only be averted by a termination of pregnancy. Such a termination was lawful. The Supreme Court accepted the evidence that had been adduced in the High Court that the girl had threatened to commit suicide if compelled to carry her pregnancy to full term, and deemed that this threat of suicide constituted a real and substantial risk to the life of the mother. On this basis, the High Court injunction was lifted. The second referendum on abortion in Ireland was held on the 25th of November 1992. The electorate were asked to vote on 3 proposed amendments to the Constitution. The 12th Amendment, which was designed to exclude the risk of suicide as a ground for lawful abortion, was defeated. However, the right to travel and the right to information were accepted, and Article 43(3) of the Constitution were further amended to reflect the position. Following the referendum, the issue of information on abortion was dealt with in legislation. The Regulation of Information Services Outside the State for Termination of Pregnancy Act 1995 makes it clear that in general the provision of abortion information is unlawful in Ireland except in very restricted circumstances, and that position has remained until now. As you all know, in December 2009, the European Court of Human Rights heard a case brought by 3 women in respect of the alleged breach of their rights under the European Convention of Human Rights in regard to abortion in Ireland. This is known as the ABC versus Ireland case. All of the applicants were women who unintentionally became pregnant and who travelled to the UK for abortions. The European Court of Human Rights accepted that Article 43(3) of the Irish Constitution, as interpreted by the Supreme Court, provides that it is lawful to terminate a pregnancy in Ireland if it is established as a matter of probability that there is a real and substantial risk to the life, as distinct from the health of the mother, which can only be avoided by a termination of the pregnancy. This has not been altered by this judgment. The court found that in the case of Miss A and Miss B that there was no violation of their rights, and they dismissed their applications. They found that there had been a violation of the applicant's right to privacy and family life, contrary to Article 8 of the Convention in the case of the third applicant, Miss C. The court held that there was no accessible and effective procedure to enable her to establish whether she qualified for lawful termination of pregnancy in accordance with Irish law. The court ruled that no criteria or procedures have been laid down in Irish law by which that risk is to be measured or determined, leading to uncertainty, and held that further legal clarity was required. Following on from this judgment, the government established an expert group in January 2000 to advise on how this matter could be properly addressed. The group was made up of experts in the fields of obstetrics, psychiatry, general practice, law, regulation and public policy. It met 9 times from January to October and submitted its report to the Minister for Health on the 13th of November. I know that some of the members of the Oireachtas present here today have made statements in the Dáil or in the Seanad on the report, and I hope that you've all had time to pursue it carefully over the Christmas break. I won't revisit the report, although I would like to say a few words about one of its chapters, which I believe will be the focus of these hearings. Chapter 6 illuminates possible avenues for the assessment of the entitlement to lawful termination of pregnancy in Ireland for the delivery of this medical treatment. It discusses the possible qualifications of the doctors involved in this process, the numbers of doctors that would be responsible, and the locations where the terminations might take place. It also provides a lengthy discussion on the formal framework to review the initial clinical decision, which is one of the main requirements coming from the judgment. It's important that I set out the nature of the decision reached by the government last December. They decided that we would have primary legislation which will confer powers on the Minister to make regulations under a new Act. It also agreed that it will consider the matter further when the Department and the Minister have developed proposals based on policy options set out in the report. It is clear that there is much work that remains to be done by the Department on the policy requirements to be given effect to by a new legislative framework. And again, I point out that this committee's deliberations will be most welcome in the context of the work to be carried out. The Department will also further engage with the Oireachtas when the heads of bills have been developed. In conclusion, Mr Chairman, I look forward to hearing your deliberations on this process and to the assistance it will be in the Department's policy work in this area. Thank you.
Thank you very much, Ms. Luddy. I want to welcome Mr Kieran Murphy and Ms Caroline Spillane from the Irish Medical Council. And Mr Murphy, the floor is yours. If you want to stand, you may. If you prefer to stand, you can do so.
I'm happy to sit if the members are
That's
happy
fine.
to sit.
Yep.
On behalf of the Medical Council, I welcome the opportunity to provide the Joint Committee on Health and Children with views which will be of assistance to the committee in formulating its report to government on issues which need to be addressed in the heads of bill and draft regulations. I'd like firstly just to say a few brief words about the role of the Medical Council. This is very relevant in the context of a discussion about the recent government decision and the publication of the expert group report. The Medical Council is a statutory body responsible for the regulation of doctors in Ireland. Its purpose is to protect the public by promoting and ensuring the highest standards among doctors. From the day a student first enters medical school until the day they retire from practice, the Medical Council works to ensure that medical education and training remain up to date and is benchmarked to the highest international standards. That the Medical Council sets standards for all undergraduate education and postgraduate training of doctors, and also requires that all doctors fulfill ongoing professional competence requirements to ensure they keep their knowledge and skills up to date throughout their professional lives. In the interest of patient safety and the protection of the public, the Council has been vested by the Oireachtas with sole responsibility to ensure that only those doctors with the necessary education, training and skills are registered to practice in Ireland. The Council also specifies standards of practice for doctors in the areas of professional conduct and ethics. Section 2 of the Medical Council Ethical Guidance. I hope members have been circulated with copies of the Medical Council guidelines for their information.
Thank you.
The Medical Council provides guidance to doctors on matters relating to conduct and ethics through its Guide to Professional Conduct and Ethics for Registered Medical Practitioners, the 7th edition of which was published in 2009 and which is before you today. It was developed following extensive consultation with doctors, the general public, medical schools, postgraduate medical training bodies, government departments, employers, and a range of other stakeholders. In order to ensure the guide is as relevant as possible, taking on board the views of all those consulted with, the Council established an ethics working group to oversee the development of the guide. This multi-stakeholder working group, which included Council members and non-Council members, including a number of medical and non-medical experts, was established to ensure that the guidance was both evidence-based and developed in line with best practice. The guide is a principle-based document, which must be relevant to each of the 1,800,000 doctors registered to practice in Ireland, regardless of their discipline. It covers issues as diverse as consent, confidentiality, end-of-life care, advertising, clinical trials, prescribing practices, and referral of patients. The Council's guidance provides the principles which are the cornerstone of each doctor's practice. It has been designed to support doctors in decision-making regarding conduct and ethics, and to complement other external sources of clinical guidance, procedures and protocols devised by expert bodies and employers. As you see, paragraph 21 of the guide relates to abortion. Paragraph 21.1 in the guide states, abortion is illegal in Ireland except where there is a real and substantial risk to the life, bracket, as distinct from the health, close bracket, of the mother. Under current legal precedent, this exception includes where there is a clear and substantial risk to the life of the mother arising from a threat of suicide. You should undertake a full assessment of any such risk in light of the clinical research on this issue. Paragraph 21.2. It is lawful to provide information in Ireland about abortions abroad, subject to strict conditions. It is not lawful to encourage or advocate an abortion in individual cases. Paragraph 21.3. You have a duty to provide care, support, and follow-up services for women who have an abortion abroad. Paragraph 21.4. In current obstetrical practice, rare complications can arise where therapeutic intervention, bracket, including termination of a pregnancy, close bracket, is required at a stage when, due to extreme immaturity of the baby, there may be little or no hope of the baby surviving. In these exceptional circumstances, it may be necessary to intervene to terminate the pregnancy to protect the life of the mother, while making every effort to preserve the life of the baby. All doctors are expected to adhere to the Council's guide. However, it is important to note that Medical Council guidelines are not a legal code. In drafting its ethical guidance, the Council seeks to incorporate and reference relevant legislation in order to ensure doctors are aware of the legal framework within which they operate. Section 3, the views of the Council on the implementation of the recent government decision. The Council, having examined the report of the expert group, considered it appropriate to provide the Joint Committee on Health and Children with views in relation to certain matters set out in chapters 6 and 7 of that report. The views of the Council are set out in pages 3 to 6 of this submission. To assist the reader, the Council deals with each question sequentially, using the same reference numbering as appear in the report of the expert group. Report of the expert group, chapter 6, procedures for determining entitlement and access to termination of pregnancy. Paragraph 6.2, test to be applied. In regard to the question of the test to be applied, the view of the Medical Council is, 1, legislation and or regulations should include a requirement that A, the treating doctor's opinions and rationale for decision-making must be documented. B, the diagnosis should be evidence-based and made expeditiously or within a defined time limit. C, the diagnosis should be formally notified by the treating doctors to the woman. Paragraph 6.3, qualifications of doctors involved in the process. In regard to the question of the qualifications of doctors, the view of the Medical Council is, 1, clinical decision makers must be registered in the specialist division of the Register of Medical Practitioners. 2, registration in the specialist division requires that a doctor has undertaken medical education and training benchmarked to the highest international standards. For the patient, it provides assurance that the doctor possesses the necessary knowledge and skills to engage in clinical practice at the appropriate level to be able to make appropriate clinical decisions. Paragraph 6.4, number and role of doctors. In regard to the question of the number and role of doctors, the view of the Medical Council is, 1, legislation and or regulations should set out criteria for the number and role of doctors to be involved. The Council will actively engage with the Department of Health in the development of regulations in collaboration with other stakeholders. 2, the legislation and or regulations should include a requirement that doctors involved have sufficient knowledge and skills to facilitate appropriate clinical decision making. Paragraph 6.5, emergencies. In regard to the question of emergencies, the view of the Medical Council is, 1, special procedures do not need to be developed for emergency situations. Paragraph 6.6, locations. In regard to the question of locations, the view of the Medical Council is, 1, the locations of medical facilities is a matter for the Minister for Health to determine, using criteria set out under licensing legislation. Paragraph 6.7, formal review process. In regard to the question of the formal review process requirements and attributes, section 673, composition of the review panel, section 674 of the report, and convener, section 675 of the report, the view of the Medical Council is, 1, legislation and or regulations should set out a formal framework to provide the woman with a review mechanism which is A, independent, B, accessible, C, transparent, D, competent, and E, timely. 2, the review panel should include doctors with sufficient knowledge and skills to facilitate appropriate clinical decision-making. 3, the review panel should have access to legal expertise on a formal basis. Paragraph 6.8, access to the courts. In regard to the question of access to the courts, the view of the Medical Council is, 1, following a negative decision of the review panel, the woman has a constitutional right of access to the courts. Paragraph 6.9, conscientious objection. In regard to the question of conscientious objection, the view of the Medical Council is, 1, legislation and or regulations should set out clear criteria for enabling the exercise of an individual's right to conscientious objection. The Medical Council's Guide to Professional Conduct and Ethics for Registered Medical Practitioners states, as you see in paragraph 10.1, as a doctor, you must not allow your personal moral standards to influence your treatment of patients. Paragraph 10.2, if you have a conscientious objection to a course of action, you should explain this to the patient and make the names of other doctors available to them. 2, the right to conscientious objection must be balanced against the right of the patient, particularly in the case of a medical emergency. The current Medical Council's Guide to Professional Conduct and Ethics for Registered Medical Practitioners states, paragraph 10.3, conscientious objection does not absolve you from responsibility to a patient in emergency circumstances. Paragraph 6.10, monitoring. In regard to the question of a monitoring system, the view of the Medical Council is, 1, legislation and or regulations should set out criteria for independent monitoring of the proposed structures. 2, independently verified, anonymized data should be published on relevant matters. For example, numbers of women who seek terminations, numbers of women who receive terminations, medical reasons that give rise to the treatment for clinical purposes. Report of the Expert Group, Chapter 7, Options for Implementation. Paragraph 7.2 to 7.43, implement the judgment of A, B, and C versus Ireland of the European Court of Human Rights. 1, in regard to the question of options on how to implement the judgment in A, B, and C versus Ireland of the European Court of Human Rights, the Council's view is that it is in the public interest that doctors have legal clarity when making clinical decisions. Insofar as legislation, underpinned by regulations, will provide that clarification to doctors, the Council supports its introduction. Paragraph 7.4.4, new legislation or amendment of the 1861 Act. The Council is of the view that sections 58 and 59 of the 1861 Act should be repealed. We are grateful for the opportunity to engage with the committee on this important issue and are willing to actively engage with the Department of Health if our input can support their processes for the development of legislation and regulations. Thank you.
Thank you very much indeed, Mr. Murphy. We're now going to proceed to questions and answers, beginning with the members. Deputy Billy Keller.
Thank you, Chairman. Just to welcome the witnesses very briefly, Chair, because we want to accommodate as many members as possible. Just to ask Mr. Murphy, has there ever been a doctor complained to or a complaint made to the Irish Medical Council by an individual or other colleagues for refusing to carry out a termination on foot of the X case, the Article 43.3, and also the Medical Council guidelines themselves? So I suppose the key question is, has there ever been a termination carried out in this country under these guidelines, and has there ever been a complaint made to the Irish Medical Council for a doctor refusing to carry out a termination under these guidelines as well? On the broader issue, Mr. Murphy, I'm just inquiring as to the view of the Medical Council with regard to prescriptive legislation. Would you have any concerns that it could be overly prescriptive? In other words, you know, if you got into the detail of legislation, that it could be the case where it becomes so prescriptive that it can be very difficult for a practicing clinician to carry out his or her duties, you know, without having maybe the barrister or lawyer almost tied to one's hip. It has been a view that has been expressed by some medical professionals to us at committee stage and also privately to us as well. So they would be just the two questions that I have on that particular issue. On the broader issue of the Irish Medical Council, prior to the A, B and C case, you know, was there difficulties, and had the Irish Medical Council and its members, had they, you know, come across difficulties at clinical decisions being arrived at prior, or, well, we still haven't got legal clarity or legal certainty. We must also be reminded that legislation will be passed not by the government but by the houses of the Oireachtas. But in the meantime, you know, how did you actually deal with these particular issues without the clarity that is being sought by people now?
Okay, thank you. And could I just, we're going to take them in blocks of 3 to 4 questioners, and could I ask members to facilitate a recording of the proceedings to stand when they're giving their address, please? Deputy O'Quillan, you have 3 minutes.
Well, Guramahagat, and I join in the welcome to Dr. Murphy and Ms. Behan on behalf of the Medical Council. And I note from the guidelines for registered medical practitioners in section 21.1 that you have referred to. It states abortion is illegal in Ireland except where there is a real and substantial risk to the life as distinct from the health of the mother. On the current legal precedent, this exception includes where there is a clear and substantial risk to the life of the mother arising from a threat of suicide. So that is currently the situation in relation to the guidelines issued to the some 18,000 members of the registered members of your council. You go on to say you should undertake full assessment of any such risk in light of the clinical research on this issue. Now, in relation to clinical matters, in the course of your contribution, Dr. Murphy, you made the point, clinical decision makers must be registered in the specialist division of the Register of Medical Practitioners. I presume in that situation, I mean, first of all, in relation to many of the situations that present, we're talking about obstetricians, gynaecologists, obs and gynae. In relation, that must be one of the specialist divisions, I presume, if you could offer clarification. And I presume that psychiatrists, of which I understand you're one yourself, that is a specialist division within the register. If you could clarify, expand on that for us. And my question immediately arising from that is there an adequate number of practitioners so registered, and are they present or are they available to all maternity settings across this jurisdiction on a 24/7 basis? I think it's critically important that we have the certainty that there is sufficient qualified staff in order to carry out the respective responsibility of clinical decision-making.
Thank you, Deputy. And talk to Matthew McGrath. Deputy, you have 3 minutes.
I won't take 3 minutes. I too want to welcome the expert witnesses here this morning and thank them for their outlining their positions for us. I want to ask the question, did the Department of Health issue any instructions or guidance in any form whatsoever to the expert group beyond its terms of reference?
Relevant to the Medical Council, sorry.
Well, the Department of Health.
No. We agreed at our meeting, the rubrics of the meeting, at our meeting last day, which you were present at.
Yes.
In terms of how we would structure a meeting today. So, carry on.
It's not relevant to the Department of Health.
No.
But we had a submission from the Department of Health.
From our meeting last night, which you remember, Robin,
Yes.
was present at, which you agreed to, the Department of Health will make an opening statement outlining the parameters of where we are today, and we'll come back at a further stage following on from the publication of the heads of the bill. Thank you.
So we're not allowed to ask them any question?
Not today, as agreed at our meeting, of which you were a member of last night, which you were present and agreed to.
Of course I remember.
And you agreed to the decision of our committee last night, the meeting agreed unanimously to the decision.
So we cannot ask them.
Thank you.
When will we get the
So
opportunity?
draft your questions to the Medical Council, please.
Well, I'll desist for the moment, so thank you.
Thank you very much. Okay. And last Deputy Kerry Conway.
Again, I'd like to take this opportunity to welcome the members of the Medical Council. I think a lot of the questions have already been asked, and so I just have one. In relation to your medical guidelines, you talk about conscientious objection. I just wonder if you could elaborate and maybe give us some examples of what a conscientious objection, how that would manifest itself in day-to-day practice for some of your members, and maybe you could outline some real-life examples for the committee in relation to that.
Thank you. Mr. Murphy, I'll take you now, and then I'll come back to members of the committee again then.
So I think that it's important that members are aware that I think that the Council is represented today both by the President, myself, and also by the CEO, Caroline Spillane. And so we will, if members are happy, we will share
Yes.
I think responses to the questions.
And I want to welcome Ms. Spillane, who's been here before with us as well, so you're very welcome as well.
So if I'll start off by answering some of the questions that have been asked, and then Ms. Spillane will then follow on. So moving first to Deputy Kelleher, with regard to your question over whether or not the Council has ever received a complaint about a termination of pregnancy. To the best of my knowledge, we have not received a complaint in this section of the guide. You'll be aware, looking at the guide, that the guide is a very principled document. It's a high-level document. It covers a range of different.
We members that can't hear at the back, so we might stand if you wouldn't mind, please.
Okay.
Thank you.
I can shout a bit louder if that's helpful. Sound. Okay. So will I start again, or
Sure,
will
please.
I?
Thank you. Yes,
Okay.
please.
So with regard to the question that Deputy Kelleher raised, which was the issue of whether or not the Council has received any complaints really regarding termination, I would say that to the best of my knowledge, the Council has not received any complaints about terminations of pregnancy. I think as you look at the guide, you will see that it is a high-level principle-based document. We cover a range of different scenarios in the guide, from consent, capacity, abortion, but a whole range of other issues. And I think that, as you will see from our website, we categorise our complaints under a variety of different sections, and Ms. Spillane will elaborate on this further. But as I say, to the best of my knowledge, we have not received complaints with regard to the termination of pregnancy. I think that Deputy Kelleher also raised the issue of whether or not the Council had concerns that the legislation would be unduly prescriptive. I mean, obviously, it's a matter for the Oireachtas to pass legislation. The purpose of the meeting today and over the next 2 days is for you to inform yourselves of the concerns and the views of the range of stakeholders that are involved in this debate. The Medical Council, of course, but also the profession, the advocacy groups, the legal groups, and it is only by formulating and involving and being informed by the views of a range of different stakeholders that will enable you to formulate legislation that I think is going to protect the public. Because clearly, from the Medical Council's point of view, our primary responsibility is to protect the public. And our submission is guided today, like all aspects of our work, by ensuring that really whatever happens in this debate, that the public are protected, and that if you decide to pass legislation and underpinned by regulations, that the protection of the public is paramount. I think that the Deputy Kelleher also raised a question about talking about differences with sort of clinical situations. I would suggest that this is perhaps more a question that should be asked to the obstetricians and to the psychiatrists who are presenting really before you later on today. Moving on to Deputy O'Quailon. Deputy O'Quailon asked a question about our medical council guidelines, and he's quoted the first section of the guidance on abortion. I think it's important to understand, as we mentioned in our submission, that the guidelines that the council has published are not a legal code. They are not a legal code. They are guidelines to assist doctors in their practice. It's also important to remember that all doctors work within an environment in which there are lots of different guidelines. So, for example, doctors work within areas that they are supported by guidelines in their by practice guidelines. So their sort of training bodies will sort of publish guidelines in the management of specific scenarios. And I think that it's important that members understand that medical council guidelines are a further, if you like, a further set of guidelines in a framework which is comprised of many different guidelines, which are all underpinned and must be consistent with the law. Because first and foremost, we are all bound by the law of the land. And so consequently, any guidance that is offered by any other body, such as the Medical Council, must be consistent with what the current legislation is. I think in relation to the question raised by Deputy Conway, when you've asked for sort of a number of examples to illustrate conscientious objection, I think with respect, I would suggest that this is perhaps more appropriately a question asked of both the psychiatrists and the obstetricians who will be presenting later today, because it is the views of psychiatry and obstetrics that will inform your knowledge with regard to the scenarios that these individuals find themselves with regard to this issue. I'll now pass over to Ms. Behan, who may wish to further expand on some of those replies.
Thank you. Ms. Behan.
Good morning. Just to take just a number of those questions, I suppose the question that was posed by Deputy Kelleher in regards to the Medical Council's complaints process. Our system for categorising complaints outlines the number of complaints that the Medical Council would receive in any 12-month period, and I think for 2012 we received approximately 420 complaints. But these are categorised into very broad areas such as treatment or professional standards, and of course many complaints concern a number of related issues and are such not categorised in the narrow way that has been suggested here. But to the best of my knowledge, in agreement with the President, we have not received any complaint regarding this section of the Guide to Professional Conduct and Ethics. I suppose just to say that hypothetically, if the Council were to receive a complaint, the Council has quite a sophisticated complaints management process that is defined through the Medical Practitioners Act, which would in the first instance necessitate the investigation of the complaint by the Preliminary Proceedings Committee. And if that committee felt that there was a prima facie case, then an inquiry may be held in relation to that specific complaint. As regards Deputy O'Quailon's question on registration, so there are 18,000 doctors registered with the Medical Council, and they're registered in 5 different divisions of the Medical Register. The first is the Supervised Division, there is the Trainee Specialist Division, there's the General Division, there is the Specialist Division, and I'll go on to talk about that, and then there's a subdivision which is the Intern Division of the Trainee Specialist Division. As I said, there's approximately 18,000 doctors registered, a minority of those would be on the specialist division. However, there are in or around 3,000 to 4,000 doctors who are currently registered with us in this division. The reason that it's difficult to be precise on numbers is that the register is quite dynamic and changes literally on a day-to-day basis. We have conducted some surveys amongst registrants. So, for example, we know that most of the registrants that are registered with the Medical Council practice full-time rather than in a part-time capacity. And then within the specialist division, we have a sub-categorisation for some of the specialist areas that Deputy O'Creelon has mentioned. All of this information is available on the Medical Council's annual report and also available on the Medical Council's website. Any member of the public, of course, can search the Medical Council's website for information and details about their doctor. We have a facility on the website called Search for a Registrant, and approximately 250,000 people would have used that facility in 2012. So we find that that's a very valuable resource for members of the public and those in health professions who wish to understand the qualifications of the doctors that are operating in the health system. I think that the President has outlined in the submission made by the Medical Council that to be on the specialist division of the medical register requires that a doctor's education and training is benchmarked to the highest international standards, and so the Medical Council can stand over the qualifications, the education, training and competence of doctors who are on the specialist division of the medical register.
Thank you. Okay, we have 7 members who've indicated now, so I'm conscious of time and I want to get as many people as I can in as well who haven't indicated. So the next 3 speakers will be Senator Colin Burke, Deputy Regina Doherty, Deputy Dennis Naughton. Senator Burke.
Thank you very much. Thank you, Professor Murphy and Ms. Spillane, for the very comprehensive and concise submission. It's just in relation to the issue of the expert group, where it gave a number of different options in relation to dealing with the issue of suicide. It set out about 2 psychiatrists and an obstetrician, just 2 psychiatrists. I'm just wondering, from your own point of view and from your experience in the Medical Council, what do you think of the 3 options that are proposed, the most workable option, if that issue has been discussed? And a second issue arises, I know we're getting a submission later on today, where it sets out that the 3 Dublin hospitals have perinatal psychiatry specialists, and that they're the only 3 of the 19 units, 19 maternity units in the country that have that specialist category. I'm just wondering, what's your own view in relation to where there is a threat of suicide, as regards whether the regulation should recommend that the people dealing with this issue, that the particular patient would come in under their remit in arriving at a decision?
Thank you, Senator. Deputy Regina Doherty.
Thank you. First of all, thanks for coming in today and for your time. Can I specifically ask you, with regard to the threat of suicide, how many terminations due to the threat of suicide have actually been carried out in Ireland since the X-case judgment? And can I also ask you to specifically explain to me that when you spoke earlier on where there was a need for a termination, where the life of the woman could only be averted by that termination, can you describe to me the procedures that would lead up to, when you talk about the risk of assessment, that would lead up to the decision being made that it was the only course of action that could be taken place that could save a woman's life? I'd be grateful. Thank you.
Thank you, Deputy. Deputy Dennis Naughton.
Thank you, Chairman. A couple of the questions that I want to ask have been asked. I'm not going to repeat those, but 2 questions that I have for the Medical Council. First of all, in relation to the Guide of Professional Conduct and Ethics that's currently in place, which is the 7th edition, can I ask, prior to the current edition and subsequent to the X-case decision in 2002, were there similar guidelines in place? Have they been replicated in the 7th edition, or have they changed based on medical practice over that period of time? If you could just clarify that. The second question that I have is specifically in relation to your submission. regarding the point that you make in the submission that you don't believe that there should be specific provision made for emergencies. Could you elaborate as to why you don't believe there should be specific provision made for emergencies? And can I relate back to what I think is a fundamental question that has been raised by Deputy O'Quailon, and can I compliment Ms Spillane for her response? I think she did very well in avoiding the question. The question is, have we got enough obstetricians in the country, both in numbers and geographic spread, to ensure that whatever provision is made in legislation can be implemented on the ground in the 19 maternity hospitals that we currently have? And also, following on from Deputy O'Quailon's question, and in light of the comment that you've made regarding emergencies, are you confident that in an emergency situation there would be enough specialist expertise available in each of the current 19 facilities to make a determination in relation to the individual case associated with the risks to an expectant mother?
Thank you, Deputy. Mr Murphy.
So perhaps I could deal with Senator Burke's questions first. He makes the point about whether or not the Council has a view on the number and the role of doctors that should be involved in making the decision. If I can refer members to the submission, this is paragraph 6.4, page 4 of our submission, in which we say, in regard to the question of the number and role of doctors, the view of the Medical Council is that legislation and or regulation should set out criteria for the number and role of doctors to be involved. The Council will actively engage with the Department of Health in the development of regulations in collaboration with other stakeholders. And 2, the legislation and or regulations should include a requirement that doctors involved have sufficient knowledge and skills to facilitate appropriate clinical decision making. So again, the role of the Council, its primary role is to protect the public. And we do that by ensuring that doctors have the necessary knowledge and skills to practice safely. So as Ms Spillane has outlined, our specialist division we see as a hallmark of quality. So we see that a doctor who is registered in the specialist division has a standard of training that is benchmarked internationally with the best in the world. And so it is the Council's view that a doctor should be in the specialist division of the register in order to make these decisions. And that gives the public assurance that the decisions are being made by the most appropriately qualified individuals. I think that Senator Burke's question about the numbers of perinatal psychiatrists, and I think that I think you will hear later this afternoon a submission from a joint submission from these 3 perinatal psychiatrists. I think it is a matter for I think the HSE and for the employers to determine whether or not there is sufficient capacity in the health service to meet the needs. But you know, I'm sure that you will ask the perinatal psychiatrists in particular whether or not they feel that there is sufficient capacity in the system. With regard to the question on suicide, I think the question was whether or not how many terminations have been carried out since the X case. The Council does not have this information. I mean, I think it's important for members to be aware that the Council is made aware of situations when a complaint is made. So if a complaint is made to the Council, and as we heard from Ms Spillane earlier, the Council last year had approximately 420 complaints. If the Council receives a complaint about any issue, we have very well-established procedures, very robust procedures to ensure that that complaint is thoroughly investigated. We have a committee of the Council which has a large number of powers to be able to adequately investigate that complaint. We take every complaint seriously. On the basis of these deliberations by that committee, a decision is made as to what should happen to that complaint. In certain circumstances, that complaint proceeds to an inquiry. And I think many members will have seen over the last number of years, with the advent of the Medical Practitioners Act, we now have inquiries held in public. In the past, inquiries have always been held, but they were held in private. But with the new legislation that was commenced in 2008, all or almost all of inquiries are held now in public, unless there's a particular reason, a particular sensitive reason why the inquiry should be held in private. I think with regard to the question of the guidelines, and